You're listening to the Bare Metal Cyber Prepcast, created to help you succeed in your educational journey. Learn more at baremetalcyber.com, where additional prepcasts, books, and training materials await. Let's get started. The Telecommunications Act of 1996 significantly reshaped U.S. communications law, and one of its most enduring privacy features is the regulation of Customer Proprietary Network Information, or CPNI. CPNI refers to information that carriers obtain through their provision of telecommunications services, including call records, billing details, and information about the services a customer subscribes to. Congress recognized that carriers had privileged access to sensitive information that could easily be exploited for marketing or unauthorized disclosure. As a result, the Act requires carriers to protect CPNI through strict safeguards, including customer authentication for account access and limits on sharing with third parties. For learners, CPNI illustrates the principle that service providers must treat information they hold as custodians, not owners, and that privacy protection is an essential element of trust in telecommunications infrastructure. CPNI has a carefully defined scope that distinguishes between information obtained solely by virtue of the carrier-customer relationship and other publicly available data. Safeguards extend beyond simple non-disclosure, requiring carriers to implement authentication measures that prevent social engineering or unauthorized access to records. These authentication standards became especially important following high-profile incidents of pretexting, where bad actors impersonated customers to obtain call logs. Carriers must maintain detailed records of CPNI access and disclosures, ensuring accountability. For learners, this demonstrates how privacy protections evolve in response to threats. By embedding authentication and record-keeping into compliance programs, telecommunications providers ensure that personal network information is shielded against both external attackers and insider misuse. The use of CPNI for marketing is subject to strict consent rules. Carriers may use CPNI to market related categories of services with an opt-out mechanism, but marketing unrelated services or sharing data with third parties typically requires opt-in consent. These regimes reflect a balance between operational practicality and consumer control. Carriers must clearly notify customers of their rights, offer meaningful opportunities to opt out, and ensure third-party access is tightly controlled. For learners, these distinctions highlight how regulators calibrate rules to context. Related service marketing may pose lower risks, while unrelated use or third-party disclosure is more intrusive, requiring stronger consumer protections. The framework illustrates a tiered model of privacy governance, where risk determines the level of consent required. Breach reporting obligations further extend CPNI protections. Carriers must notify law enforcement within 7 business days of a breach before alerting affected customers, ensuring that investigators can pursue criminal inquiries without premature disclosure. Record-keeping requirements oblige carriers to maintain logs of security incidents and mitigation steps. For learners, this structure reveals how privacy law intersects with national security and law enforcement priorities. Breach reporting in the telecommunications sector is not merely about consumer notice, but about preserving the integrity of investigative processes. This coordination underscores the dual role of carriers as both service providers and critical infrastructure actors, entrusted with sensitive communications that may be targeted by sophisticated adversaries. Cable subscriber privacy protections arise from the Cable Communications Policy Act of 1984. Recognizing that cable operators collect large amounts of personally identifiable information about viewing habits, billing, and equipment, Congress imposed limits on how this data can be used or disclosed. Cable operators may only use subscriber information as necessary to provide service, detect unauthorized reception, or support other legitimate business activities. Any disclosures outside this scope require informed consent. For learners, this shows how Congress drew boundaries around entertainment data long before the rise of digital streaming. Watching television may seem benign, but it reveals preferences and behaviors that carry social and political sensitivities, making protections essential. Cable operators must also provide privacy notices to subscribers at the time of enrollment and annually thereafter. These notices must explain what information is collected, how it is used, under what circumstances it may be disclosed, and how long it will be retained. Delivery must be conspicuous and accessible, ensuring subscribers understand their rights. For learners, this emphasizes how transparency is the first line of defense in privacy regulation. By requiring notices at the start of the relationship and periodically thereafter, the Cable Act ensures that consumers are continually reminded of their rights and the obligations of service providers. This ongoing notification model anticipates the need for reinforcement in environments where relationships span years. Consent standards under the Cable Act are strict. Operators cannot disclose personally identifiable information without prior written or electronic consent, except under narrowly defined exceptions such as law enforcement orders or audits. Redisclosure by recipients is also prohibited, ensuring that once data leaves the operator, it does not circulate beyond its intended use. For learners, this reflects the principle of containment in privacy law. Protecting consumers is not only about restricting initial disclosures, but also about preventing further diffusion once information is shared. Redisclosure restrictions create a chain of accountability that ensures data remains within its authorized bounds. Retention limits under the Cable Act require operators to keep subscriber records only as long as necessary to achieve legitimate business purposes. Once the information is no longer needed, it must be securely destroyed. This prevents indefinite retention of sensitive records, reducing the risks of misuse or breach. For learners, this illustrates how data minimization principles permeate different sectors. The more data that is retained, the greater the exposure. By requiring secure destruction, the Cable Act reduces the attack surface and enforces discipline in information governance, even in industries where records may be seen as low risk compared to financial or health data. Law enforcement access to cable subscriber data is also regulated. The Cable Act requires a court order, issued with notice to the subscriber, before operators may disclose personally identifiable information to government authorities, except in emergencies or certain limited cases. This judicial oversight ensures that access is justified and subject to checks and balances. For learners, this provision underscores the balance between privacy and law enforcement needs. Access to consumer viewing or billing records cannot occur casually but must be approved by the judiciary, reflecting constitutional concerns about surveillance in the private sphere. Audience measurement activities, such as tracking viewership to support advertising or programming decisions, are permitted only if information is aggregated or de-identified. This ensures that individual subscribers are not personally identified in reports. For learners, this highlights how de-identification functions as a compromise between business needs and consumer protection. Operators gain insights into audience behavior while individuals maintain privacy. Yet this also raises questions about the adequacy of de-identification in modern analytics, reminding learners that safeguards must evolve as re-identification techniques advance. Consumers have remedies under the Cable Act, including the ability to bring civil actions for damages, attorneys' fees, and injunctive relief if their privacy rights are violated. This private right of action reinforces accountability by allowing individuals to pursue claims directly rather than relying solely on regulators. For learners, this demonstrates how enforcement power is distributed in U.S. privacy law. The combination of regulatory oversight and private litigation creates a dual enforcement model, raising compliance stakes and providing multiple avenues for redress. Platform convergence complicates compliance today. Cable operators increasingly deliver services through app-based streaming platforms, raising questions about whether cable-specific protections apply in digital contexts. Courts and regulators continue to adapt interpretations, but operators must assume that privacy obligations extend across delivery modes. For learners, this reflects the reality of technological convergence. Legal frameworks designed for physical infrastructure now apply to hybrid platforms that blur lines between telecommunications, cable, and internet streaming, requiring adaptable compliance strategies. Finally, the interaction between federal and state laws requires careful navigation. While the Cable Act sets a baseline, States may impose additional protections or create overlapping requirements. Preemption boundaries can be complex, with federal law sometimes displacing state regulation and sometimes coexisting. For learners, this highlights the layered nature of U.S. privacy law. Companies cannot rely solely on federal compliance. They must evaluate state overlays and ensure harmonization. Operationally, this means aligning privacy controls for both telecommunications and cable obligations within unified compliance programs, reducing the risk of gaps while maintaining consistency across services. For more cyber-related content and books, please check out cyberauthor.me. Also, there are other prepcasts on cybersecurity and more at baremetalcyber.com. The Video Privacy Protection Act, or VPPA, was enacted in 1988 after a Washington newspaper published a Supreme Court nominee's video rental history during his confirmation hearings. This episode demonstrated how viewing records, even of seemingly innocuous films, could reveal personal details and subject individuals to embarrassment or unfair judgment. The VPPA prohibits disclosure of personally identifiable information tied to consumers viewing history without their consent, and although it was originally crafted for video rental stores, courts and regulators have extended its application to modern streaming services and digital platforms. For learners, this illustrates how privacy laws adapt over time. The intent behind the VPPA to protect individuals' entertainment choices from becoming public without permission remains just as relevant in today's environment of on-demand streaming and personalized content delivery. Personally identifiable information under the VPPA includes not only names and addresses, but also data that links specific viewing selections to a particular individual. In the digital age, this can encompass account identifiers, device IDs, or even cookies when they can reasonably connect a consumer to a viewing history. The sensitivity lies in the potential for behavioral profiling and inference. For example, viewing history might reveal political leanings, health concerns, or cultural affiliations. For learners, this demonstrates how context magnifies risk. Watching certain documentaries or shows can expose intimate beliefs or conditions, making even entertainment data worthy of heightened protection. Consent is central to the VPPA. Disclosures of viewing history require contemporaneous, informed, and written consent, often captured electronically. Courts have emphasized that blanket or indefinite authorizations are insufficient. Consumers must knowingly and specifically agree to disclosures at or near the time they occur. This consent discipline ensures that consumers retain meaningful control and are not tricked into overbroad permissions. For learners, the VPPA's consent requirement highlights how privacy rights hinge on clarity and timing. Consent must be fresh, informed, and tailored, reinforcing autonomy in environments where data sharing can easily become routine and invisible. The VPPA allows limited exceptions to its disclosure prohibitions. Disclosures may occur in the ordinary course of business, such as for billing, debt collection, or order fulfillment, and in response to law enforcement requests when proper procedures are followed. Even within these exceptions, the principle of minimization applies. Only the information necessary for the purpose may be disclosed. For learners, this shows how the VPPA balances privacy with operational realities. Businesses can function, regulators can investigate, and courts can obtain evidence, but none of these justifications open the door to unlimited sharing. Precision and necessity remain the guiding standards. Retention and destruction obligations under the VPPA require that viewing records be kept only as long as needed for their intended purpose and then destroyed securely. This prevents indefinite retention, which could magnify the risk of misuse or breach. For learners, this aligns the VPPA with broader privacy principles, particularly data minimization. Retaining fewer records reduces exposure and ensures that sensitive entertainment data does not become a long-term liability. This principle is critical in digital platforms that may otherwise default to storing information indefinitely, sometimes without considering long-term consequences for consumer privacy. Enforcement of the VPPA is notable for its private right of action. Consumers can sue for statutory damages of $2,500 per violation, plus attorneys, fees, and potential punitive damages. Litigation under the VPPA has expanded significantly in the streaming era, with class actions targeting improper sharing of viewing data with advertisers, analytics firms, or social media platforms. For learners, this litigation trend demonstrates how statutory damages can create significant risk exposure for companies. Even seemingly technical missteps in data flows can produce class action liability, underscoring why organizations must scrutinize their information sharing practices carefully. The Driver's Privacy Protection Act, or DPPA, was enacted in 1994 after reports that stalkers and criminals use state motor vehicle records to target victims. The DPPA regulates how personal information from motor vehicle records may be accessed, used, and disclosed. It applies to state departments of motor vehicles and to any entities or individuals who receive and use this data. Covered information includes names, addresses, phone numbers, social security numbers, photographs, and driver's license details. For learners, the DPPA illustrates how privacy regulation responds to real-world harms. By restricting access to sensitive state records, Congress aimed to prevent exploitation of government databases for unsafe or unauthorized purposes. Permissible uses under the DPPA include functions such as law enforcement, insurance underwriting, vehicle safety recalls, and other public interest activities. These uses recognize that motor vehicle data can serve legitimate purposes essential to safety and commerce. However, the law sharply restricts marketing uses unless the driver has provided opt-in permission. For learners, this dichotomy underscores the difference between essential and discretionary uses of personal data. Activities tied to safety or regulation may justify access, but commercial solicitations are considered intrusive unless explicitly authorized by the individual. Redisclosure and resale duties are also integral to DPPA compliance. Entities that obtain motor vehicle records must ensure that downstream recipients adhere to the same restrictions. This creates a chain of accountability similar to redisclosure limitations in cable and telecom statutes. For learners, this reinforces the principle of data stewardship. Once sensitive information leaves its original custodian, obligations follow it downstream. Each recipient must maintain the same level of discipline, preventing dilution of protections through successive transfers. Security and contract expectations under the DPPA require regulated entities to adopt safeguards against unauthorized access and to embed privacy commitments in agreements with vendors. Audits and monitoring may be required to demonstrate compliance, especially for organizations that process large volumes of motor vehicle data. For learners, these requirements mirror broader trends in privacy regulation. Obligations extend beyond policy statements to practical controls and oversight mechanisms. Compliance is not only about permission, but also about operational discipline in managing sensitive datasets. The DPPA coexists with state-level motor vehicle privacy statutes, some of which impose stricter protections. States may add requirements for notice, consent, or breach reporting, creating a patchwork that organizations must navigate. For learners, this highlights the layered character of U.S. privacy law. Federal law establishes a baseline, but state laws can elevate standards, requiring organizations to apply the strictest applicable rule to maintain consistent compliance. Vendor and data broker oversight is increasingly important across VPPA and DPPA contexts. Streaming platforms may share viewing history with third-party analytics or advertising partners, while motor vehicle data often flows into insurance or investigative services. Both statutes demand disciplined oversight to ensure third parties comply with statutory obligations. For learners, this emphasizes a recurring compliance theme. Accountability cannot be outsourced. Organizations must monitor their partners and maintain documentation to demonstrate that vendor activities align with the law. Training and documentation are the backbone of compliance with telecom and media privacy statutes. Staff must be educated on consent requirements, permissible uses, and disclosure restrictions, while organizations must keep records of notices, consents, and access requests. For learners, this reflects the operationalization of privacy law. Compliance is not achieved through abstract principles but through tangible processes, policies, and evidence that can withstand audits, investigations, or litigation. Embedding privacy into organizational culture ensures that these statutory obligations become daily practice rather than occasional considerations. In conclusion, the VPPA and DPPA extend the broader framework of telecom and media privacy into specific domains, entertainment, and motor vehicle data that carry unique sensitivities. Together with the Telecommunications Act and the Cable Act, they illustrate how Congress tailors privacy rules to different sectors, embedding safeguards, consent disciplines, and permissible use controls. For learners, the synthesis is clear. Privacy in communications and media is grounded in contextual obligations, requiring CP&I safeguards for telecom, subscriber rights for cable, explicit consent for video data, and strict permissible use boundaries for motor vehicle records. This layered framework demonstrates how U.S. privacy law addresses distinct risks while reinforcing universal principles of transparency, consent, and accountability. Thanks for tuning in to the Bare Metal Cyber Prepcast, your trusted source for cybersecurity news and insights. Remember to subscribe at baremetalcyber.com so you never miss an update. And visit cyberauthor.me for best-selling cybersecurity books that equip you with expert knowledge. Until next time, stay secure and stay vigilant.